Founder-Friendly Standard, written by Isaiah Engel, Dan Flanagan, and Adam Bloom. Narrated by Isaiah Engel. Founder-Friendly Standard is a checklist of legal issues that are often overlooked when setting up a new business and funding it for the first time. Unless these issues are handled up front, they can fester into disputes around voting rights, stock vesting, non-competes, and other terrible, no good, very bad things. Founder-Friendly Standard is the first standard of its kind written by entrepreneurs to define in legal terms what the overused, no, tortured phrase founder-friendly should actually mean. Everyone in the startup world says they're founder-friendly, especially angel and VC investors. That is until you sign their paperwork. And then they sit on your board and become your worst nightmare. Don't think it could happen to you? It happened to me. It happened to my friends. It happened to Steve Jobs, Sean Parker, and countless other entrepreneurs. My friends and I wrote Founder-Friendly Standard in 2017 to help you avoid our terrible mistakes and go further. Since then, entrepreneurs in more than 100 countries have read this standard, and you're about to as well. Well, actually, I'm about to read it for the 513th time, but you can listen along. Here's the text of the Founder-Friendly Standard. A company meets the Founder-Friendly Standard version 1.1 when its equity, financing, corporate governance, and founder labor agreements meet all the standards from every section below. Section 1. Voting equity. Individuals who work for the company and are instrumental in its inception, founders, receive a class of equity such as common stock, which provides no less than 24 votes to 1 vote of stock held by investors or employees. Investors receive a class of equity such as Class A preferred stock, which will have 1 vote per share with a higher par value justified by a liquidation preference. Employees and contractors receive a class of equity such as Class B common stock, which carries 1 vote per share and does not have a liquidation preference. The first board consists only of founders. The term of the board is 1 year. After the first year, a new board is elected by the equity holders at the annual meeting. Board decisions are made by a majority vote of the board. Board members can cast no more than 1 vote on any decision. Board committees are disallowed for the first 2 years. New equity of any kind, including stock option pools, dilutes all equity holders equally. Therefore, no investor in the company has anti-dilution rights of any kind, okay? Section 2. Sweat equity. Founders agree in writing that they will give and receive performance reviews at the end of each fiscal quarter for the first 4 years. Sweat equity vests each month over a period of 4 years with a 1-year vesting cliff. Vesting begins on the date shares are issued. Founders keep all information confidential and assign the company all intellectual property created within the scope of their work for the company. Due to potentially devastating tax consequences, the company tells individuals receiving sweat equity in the United States to consult with a tax professional about making an election under Section 83B of the Internal Revenue Code. Founders who live or pay taxes outside of the United States are similarly advised to consult tax professionals about applicable local and national taxes. Non-compete restrictions only apply to employee or independent contractor agreements and do not survive termination. The company's bylaws and other investor agreements are either silent on the issue of non-competition or expressly allow competition. Section 3. Law. For at least the first 2 years of operations, the company does not agree to pay the legal expenses of any investor as a condition of investment. Sorry, guys. For at least the first 2 years of operations, the company does not agree to binding arbitration with any investor. And for the first 2 years of operations, the company does not agree to binding arbitration with any founder. Section 4. Transfers. Upon any transfer or sale of the founder's supervoting equity, the portion of equity transfers converts to the class of equity described in Section 1.3. This includes any transfer to the founder's estate, spouse, or heirs. Let me read you section 1.3 again. Employees and contractors receive a class of equity such as Class B common stock, which carries 1 vote per share and does not have a liquidation preference. The company has the right of first refusal on any transfer or sale of equity for up to 45 days, but it cannot veto a transfer or a sale. This provision is void after a company's stock is listed on a public exchange, such as NASDAQ, over-the-counter bulletin boards, New York Stock Exchange, you know the shtick. Section 5, Usage. The company's equity, financing, corporate governance, and founder labor agreements invoke founder-friendly standard as follows. Intention of the parties. The parties agree that the enclosed exhibit, the founder-friendly standard, captures the intent of the parties in creating this agreement. In the event of any discrepancy between this agreement and the founder-friendly standard will prevail. The enclosed exhibit is an exact copy of version 1.1 retrieved from isaiah.blog/founder-friendly standard. By using founder-friendly standard, you agree that founder-friendly standard LLC, or me, Isaiah Engel, is not providing you with legal or tax advice and is not a party to any agreement where this work is attached. This work is licensed to you under Creative Commons Attribution No Derivatives 4.0, which can be found at creativecommons.org. Founder-Friendly Standard is a registered trademark of Founder-Friendly Standard LLC in Dallas, Texas, United States. Important citations of the Founder-Friendly Standard. Founder-Friendly Standard has been cited in 2 major pieces of research that you should be aware of. The first is a 2019 interactive comparison between Founder-Friendly Standard and 6 popular term sheets from 500 Startups, Y Combinator, NVCA, Gust, and Sam Altman. You can find this infographic by searching the web for Founder-Friendly Standard comparison. The second piece of research is the 2020 book called Innovation Casino: Grow Digital Revenue with an Ecosystem Innovation Fund. The book, which you can find on Amazon, talks about how corporate venture capital can attract startups to their digital ecosystems with a new type of funding program that uses founder-friendly standard terms. You've been listening to the audio version of Founder-Friendly Standard, co-authored and narrated by me, Isaiah Engel. To find the standard online, search the web for Founder-Friendly Standard and click on the link to my blog, isaiah.blog. There you can read the standard and chat with me by clicking in the bottom right corner. You wouldn't believe some of the messages that I've gotten here, so hit me with your best. Until next time, the end.